We welcome everyone back, both those in the room and those who are joining us virtually. It's my pleasure to chair the second panel of today's symposium. And we'll have three speakers: Dáire McCormack-George, who's joining us from Dublin. Thank you for making the journey. Gali Racabi, who's joining us from New York, a shorter journey, but also thank you. And Sara Slinn, who is a faculty member here, but is on a sabbatical in Vancouver. So she's also flown in to join us. So thank you all. Let's start. We'll start with Dáire. And so I'll turn the floor over to you.
Great. Thanks very much. Thanks especially to Valerio in particular for extending the invitation to me to speak today. I'm delighted to be here. This is my first time in North America, so it's a real journey of exploration for me. I've got a PowerPoint, so I'll try and use that if I can. So that's the title of the paper, "The Structure of a Republican Labor Law." I titled that because the paper focuses on, and the presentation will be about, the central authority structure, the central organizing structure in employment law or labor law, namely the subordination of the worker to the employer through the managerial prerogative. So, I mean, I suppose I'm probably speaking in very basic terms. You know, I think most of us here are familiar with some of these issues, and I'm just going to run through them before I can get into my original contribution. You know, what is subordination in terms of the legal basis for it, or what does it mean in legal terms? It's the power of the employer to determine most aspects of work: what, when, where, how, and why a person does certain work. And I'm drawing here on Strato Can-Freund and his analysis, and Hugh Collins' analysis of that in a recent paper in Is the Contract of Employment Illiberal? So I think a number of you will be familiar with that paper. And Hugh Collins very cleverly analyzes the nature of the managerial prerogative as an institution of practical authority. So he justifies the managerial prerogative on this basis. He notes that it establishes a hierarchical relationship between worker and employer, and the justification of the managerial prerogative is based on the notion that the employer is more likely to achieve the shared goals of the organization on behalf of their workers, also by virtue of their superior knowledge, skills, and experience. So I think Hugh Collins presents quite a deep justification of the managerial prerogative, but I shall attempt to go somewhat deeper. The third point on the slide there, workplace in alleviating power or dealing with the imbalance of power between workers and employers, and I think that's not controversial. But the point of this paper is to contribute to a theoretical analysis of that. And so I propose to analyze or provide a high-level analysis of what practical philosophers call a normative power, which is not a causal change to one's situation, but a normative change, a change which brings about a change in one's rights and duties. I draw upon recent work of Joseph Raz in that respect, the late Joseph Raz, on the nature of a normative power as the basis for, and the normative power I'm focusing on is the normative power of one person to promise to work for another. So again, this is a paper in kind of employment or labor law fundamentals. So as I've argued at greater length elsewhere in my analysis of the link between Philip Pettit's republicanism and labor law, the normal justification of employment law or labor law to reduce the inherent imbalance of power in the employment relationship is ultimately based on a concern for people's well-being at work and in community, and in particular the value and ideal of freedom as one of the most important constituent conditions for and elements of a good life. So, like Hugh Collins, I'm going to try to reconcile this notion of the managerial prerogative with the value of freedom, but in a slightly different and perhaps more abstract way. So if the value of freedom lies at the heart of labour law, we need to understand what that value looks like, what it consists of, how it can be realised, and whether or not subordination equals domination, which I think hopefully some certain elements of this paper will resonate very clearly with what's been said by other speakers today, and I think that's one point that will. It might be controversial, but I think that's one point that will. So for Philip Pettit, any factor that can reduce your freedom of choice is a hindrance, and there are two types of hindrances, generic or vitiative and specific or invasive. So invasive hindrances are the primary concern of Philip Pettit. Well, what are they? They're conscious infringements of your freedom of choice by another person. So for him, such infringements or invasions to your freedom of choice that are do not involve the direct action of another person are not as important. So, for example, the phenomenon of structural domination or structural invasion is not considered to be as important. So invasive hindrances come in two forms. They can be dominating or interfering, and dominating hindrances are what Pettit is targeting in particular. Domination for him simply involves invigilation or intimidation. And this ideal of freedom can only be realized in a certain type of community, which he describes as a socially just and politically legitimate sovereign republic. Now, there are clear labour law implications for in such a republic, and I've explored them in more detail elsewhere, and I summarised them in the paper. I'm not going to go into them too much at this stage, because I want to turn to, I suppose, the major point of this part of the presentation and this part of the slide is the question of, does subordination equal domination? Because if domination is the antithesis of freedom, then any form of domination requires to be addressed via regulation or otherwise in a republic such as Pettit's. And so the most important question at this stage is whether subordination does equal domination. Now, there was a specific question on this, I think, earlier posed to the panel, and I think some members of the panel did consider it. So I think the most powerful suggestion that subordination is not domination is from Hugh Collins, who says that domination it cannot be equal to subordination. My suggestion is that it depends on the quality of the reasons or the quality of the laws given, and I propose to analyse certain aspects of the managerial prerogative as one category of laws which could be categorised as dominating. So perhaps somewhat like Professor Tucker, I try and identify categories of subordination, which I describe as unfree subordination and free subordination. Unfree subordination being those who are forced to work, free subordination being the category of people who freely choose to work for whatever reason. Unfree subordination, I think that's less controversial in the sense that there's a growing consensus in the Republican school of thought that workers who are forced to work, people who are forced to work, are subject to structural domination. That is to say that there is the structures of society of a republic are necessarily or do have incidental inequalities which facilitate the invasion of some invasions to some people's freedom of choice over others. The more difficult category is that of free subordination, namely those who don't actually need to sell their labour power but choose to anyway. I don't think that's entirely abstract. I think there is a category of people who choose to work maybe because they like being challenged. They want to enter the family business instead of merely living off the income of the family business. They want to enter the family business. There's also the category of worker who does so, or a category of person who does so because they feel it's the easy way rather than perhaps starting their own business with capital which they've received from their family or capital they already have. Instead of doing that, they just go and get a job and invest their capital in some other way. The point I'm trying to get at is that the difference between these two categories of subordination begs the question as to as to the scope of application of employment and labor law. Should those who are forced to work and those who freely choose to work benefit from the same types of labor protections? And this is something I've explored in brief elsewhere, but I propose to explore more deeply here. I suggest there are two consequences of the Republican perspective, or in particular that of Philip Pettit's. One is that Philip Pettit's republicanism will suggest that labor rights should be allocated in accordance with those who need them most. Those who don't need labor rights as much, for example, you can imagine a situation where there is a company, there are directors of the company. The directors of the company have rights under company law. They also have rights under employment law. One would have to ask oneself, why does such a person, and those rights would be quite strong, one would have to ask oneself why that person should have those rights over a person such as a temporary farm worker, somebody who's clearly worse off. The analogy I'm pointed to, or I'm most called by, is that of progressive taxation, namely, certainly in Ireland, those who earn least pay the least tax, and those who earn most earn the most tax, or pay the most tax. Why should the same principle not apply in respect of labor rights? There's a second consequence of the Republican perspective, which is related to a point made earlier by Professor Stefano, in terms of the threshold test for employment or employment status. There are a binary divide between different employment categories. And it's a point that was made by Hugh Collins in criticizing another theory of employment law, the capability theory. And that is that employment law requires to be individuated to a much greater degree. That's to say that there should not be merely two fixed categories of employment without with a fixed range of rights applying to one and none applying to the other. Rather, there should be, I suppose, a continuously developing categories of employment. And I suppose some inspiration I got for this was from Mark Freeland in his analysis of, and Nicola Kantouris in their analysis of the categories or variables or vectors across which employment rights range. So, for example, they refer to casual, fixed-term, and permanent employment, independent, interdependent, and dependent employment, owner, part owner, and non-owner employment or employees. Some recent categories you might be familiar with are categories which have been invented in only very recent times. Certainly in Ireland, I imagine it is the same in Canada, is the notion of essential employment during the pandemic, essential, semi-essential, and non-essential employment. Another category referred to by Professor Freeland is that of public, private, and private employment, or trainee, apprentice, semi-qualified, and qualified employment. So the point that I'm trying to make is that one needs to see employment laws as employment and labor laws responding to this need to respect people's freedom of choice and the choices that they continue to make in becoming more of an individual person, more of a free person, by individuating employment and labor law in response to their needs, but also in response to their potential contributions. So it has two aspects. One is to tailor labor rights to people's needs by allocating more labor rights to those who need more of them and less to those who need them less. And the second is to suggest that to tailor employment law to people's contributions, which means establishing more categories of employment to respect the fact that there are simply put, there are in a Republican vision of employment law, or in this particular version of Republicanism, which is offered to justify employment law, that there are inequalities, inherent inequalities in society, which is a feature of or an implication of the acceptance of social power, which are essentially unavoidable. And it's a commitment. Again, this is a commitment from this perspective of freedom and prioritizing freedom over certain other forms of certain other values, such as equality. We might contrast this with prioritizing equality over freedom, for example. So, if, as I've said so far, employment law needs to be individuated to a much greater degree, to respect people's freedom of choice and the contribution they can make to society and on the basis of the choices they have made to date and continue to make. And second, if labour rights need to be reallocated or allocated in a manner which reflects the priority in which people need them. My focus in this paper has been on is on this issue of the overarching question, the overarching problem of subordination, and in particular the legitimacy of the normative power of one person to promise to work for another. I have to make a link now to concretize the picture. It's been very abstract so far, so now getting into a much more concrete part of the paper and looking at the role that rights play and whether there can be a right to subordination and what that means. So there is a theory of rights which is consistent with Petit's republicanism, and according to that theory, in a republican justification of employment and labor law, there could be rights amongst the foundations of employment and labor law, as rights is a juridical concept, not simply as human rights, but as rights which are moral values, or the representation of moral values entrenched in the law. And the right to work, that's the right to sell one's labor power, the ability to promise to work for another person, must be considered to be one of the most basic or fundamental rights which can be entrenched in law, in constitutional law, and derivative rights deriving from that right entrenched in the subsystems of law in a particular republic. The question then is whether there can be a right to subordination. So what does that mean? Again, it seems to me to be important that if there is different categories of employment rights, as I've suggested there should be, multiple different categories, and those categories depend on the needs and the potential contribution of the worker, then we need to determine in what circumstances a person acquires rights in employment and labor law. So again, this is still very abstract. So if there is a right to subordination, that's again a right to access employment law, which derives from the right to work, which is the core right. It seems that there could be a number of questions which would form part of the what have been described as the investigative right laws concerning that right, namely, under what conditions does someone acquire the right to subordination? So I've posed a series of questions there in part based on the factors which Petit describes as a hindrance to a freedom of choice. So consider in particular the final two. Invigilation. Does the employer have the legal and or factual power to monitor or surveil the worker, and I've gone into them in more detail in my paper, at will, subject to consultation, agreement, or otherwise? If so, then how extensive is the power, and are there any legal or factual limitations on that power? Intimidation. Again, does the employer have the legal or factual power to exert further legal and or factual power over the worker at will, subject to consultation, agreement, or otherwise? If so, then how extensive is that power, and are there any legal or factual limitations to that power? The point of the question is to say, if I was going to work and if I was to fill out a sort of a survey or a form based on what I experience in work, if you were to answer those questions, the answer to those questions would determine what category of rights you would have under employment law. Now, the answers would have to be relatively detailed, but that's the gist of it. Again, I've asked the questions in respect of all 5 of the variables or forms of hindrance which Pt2 considers to be most significant, but of those, the most important are invigilation and intimidation. Does the employer have the legal or factual power to monitor or surveil the worker at will? So that, from the perspective of Philip Petit's republicanism, is probably the most important threshold test for determining whether or not a person has employment law rights. Namely, are they being surveilled or capable of being surveilled, and if so, to what extent, to what intensity, and so forth. So the questions try to solicit responses in respect of the nature of the power, the basis of the power, the extent of the power, and any limitations to them. And it would, if this is a right, if there is a right to subordination, so if there is a right on a worker to be correctly categorized for the purposes of employment law, correctly have their rights correctly allocated to them, then it would suggest that there's a correlative duty on employers to ensure that employees, or workers are allocated the correct rights. So I suppose just to sum up and kind of bring sort of, just to summarize what I've said, I suppose what I've said is some of it is quite dense. The subordination of the worker to the managerial prerogative can be justified on the basis of the normative power of one person to promise to work for another, to promise to enter into a binding contractual or promissory relationship with another person. That normative power is based in the value of freedom, which is a normative and moral value. If we look at the subordination of the worker to the employer in the light of that value, we see that there are 2 overarching categories of subordination, namely those who are forced to work and those who freely work. Once we look at those categories, that enables us to consider some necessary reforms of employment and labor law required by, or in line with this perspective, namely, 1, that employment and labor law rights be allocated so that those who are worse off have the most rights, and those who are best off have the least rights. That is not, I think it's fair to say, that is not generally the case in reality, but that's what this particular perspective calls for. And secondly, that employment law continue to be individuated to a greater degree, namely that there be further and further categories of employment created with different rights, reflecting the different needs and contributions of people in society. And thirdly, if the normative power of one person to work for another is the most basic or originating power, then we need to consider some of the implications of that for accessing employment law. So a derivative concern, a derivative power of that power is the right to subordination, that's to access employment law, and the conditions to satisfy or to obtain the benefits of that right, namely the benefits of employment and labor law, can be obtained through asking a series of questions. I've only outlined part of what a right to subordination looks like in the paper, but it's possible that on another occasion, a more fulsome exploration of the implications of the right to subordination could be established, again, in a more fulsome terms. So thank you very much for listening to my presentation. I look forward to any questions you might have afterwards. Thank you.
Yes. Okay, so turn the floor over to Gali.
So hi, I'm Gali. Thank you so much for having me. Should I do anything or? So I'd like to thank Valerio for reaching out for this wonderful hospitality here. So my name is Gali. I teach labor and employment law at Cornell Law School. So this project is titled Private Ordering, May It Rest in Peace. It's a Halloween-themed presentation. Halloween is my favorite US holiday. It's such a, not the only US, I understand there's a Canadian Halloween as well. It's certainly not the case that we have Halloween in Israel, where I'm from. And the crux of the argument that I make in this paper, in this project, is that private ordering, which was this organizing paradigm for how it is that we did labor and employment law in the US, is dead, is no more. Now, when I say it, I don't mean that private ordering was replaced by any other organizing paradigm for employment and labor law, which I refer to as work law. No, that's not the case. We didn't replace private ordering by public ordering or anything ludicrous as that, but simply dead and no more. That's the descriptive claim of this article. And the normative claim is that's a good thing that private ordering is dead, and we should celebrate it, mostly for my subjective normative account, because of worker subordination and the implicit role and the organizing role that private ordering played in the subordination of workers, in the subordinations of liberation projects, in the subordination of many other workplace-style projects. So, to demonstrate some of the claims, the broad kind of perhaps meta claims that I make, I would like to give an example. So a few weeks ago, the US Surgeon General, a top federal official in charge of public health, issued a report that relates to the effects of work and workplaces on public health. The report has much better slides than I have, much prettier slides. I urge you all to read it. The report starts, or the Surgeon General opens the report by demonstrating the stakes of the argument, the stakes of workplace health, the workplace effect on health. And it does that very effectively by dedicating the report to all the workers who died of COVID-19 and to their families. Again, kind of bringing to the forefront of the debate that this is an issue of life and death. It's really important that stakes cannot be higher. The Surgeon General then follows by pouring data and research on all of us. So, for example, he says that a 2021 survey found that 76% of adult workers reported at least one symptom of a mental health condition, an increase of 17%. He ties that number to workplace conditions, saying that 84% of respondents reported at least one workplace factor, for example, emotionally draining work, that had a negative effect on their mental health. The Surgeon General also gives out another survey of more than 2,000 workers conducted by the American Psychological Association, said that by 2022, low salaries, long hours, and the lack of opportunity for advancement were commonly reported as key workplace stressors. Now, for those astute observers of the US labor market here in the room, we can notice that low salaries, long hours, lack of opportunity for advancement are not bugs in the US labor market, but a constant theme in how work is conducted in major sectors of the economy. He continues saying that rates of anxiety, depression, social isolation, job burnout, and insecurity related to food, housing, and income rose between March 2020 and mid-2022. So that's a recent, really urgent matter. Again, the Surgeon General rightly, in my opinion, connects both food, housing, and income to the US workplace. The US workplace is the place where much of the social stakes, opportunities, and risks are being allocated. Food, housing, and income are intrinsically tied to how US workplaces function, what it is that they do in society. So the stakes are enormous, life and death. The urgency is now, things are happening now, people are suffering now. What can be done? What is the vision that the Surgeon General offers us for the US workplace? And that vision is surprisingly radical. The Surgeon General says that we ought to turn the US workplace from an institutions that create detrimental health outcomes. That's his capacity, that's his expertise, health-related outcome. He said that we need to transform the US workplace from our institution create dire, negative health outcomes to an engine of well-being. Again, for those astute observers of the US labor market, that would be quite a shift in some of those major components that the Surgeon General himself identified as leading work to be so detrimental to health. Okay, so you got us all on board. So the stakes are enormous, urgency, data supporting your case, a radical vision. What should we do with this report? So the Surgeon General says that this report can be viewed as a starting point for organizations in updating and institutionalizing policies, processes, and practices to best support the mental health and well-being of workers. So basically what the Surgeon General said that we should do with this report is pitch it to managements, not as a kind of as a soft law kind of order, but as a jumping board for internal discussion. Now, there's tension there between the stakes, the data, the urgency, and the tools that the Surgeon General thinks are available to us in conducting what can only be interpreted as a radical finish. So there's a huge tension there. And in my work, I treat this as a tension between some of the most important workplace projects out there and the tools that we have to implement them using our paradigm of what it is that we do work law with, employment and labor law with, which is private ordering. So I'm just noting this tension. So I just kind of noted other projects that came kind of to bear here in this symposium. So the good life, safety and health, minimizing or ending arbitrary power, and minimizing or ending surveillance by technologies, due process, good education, and I would add other kind of radical projects. Maybe we should stop global warming or end discrimination and sexual harassment. There's a huge tension between those worthy, urgent, high-stakes projects and the data that supports how urgent and needed they are, and the tools that we have with private ordering. Now, we can try, and some of us still do, push all of those projects into private ordering and try to maintain this paradigm, but more and more, we find ourselves doing other stuff, using other legal tools, using other frames of reference, other paradigms for what it is like to be doing labor and employment. So what is private ordering? What is this thing that I'm saying is dead? So private ordering is the paradigm, the organizing framework for US employment and labor law. It has some descriptive components and some normative ones. This is an employment law private ordering textbook. So that's not kind of I'm not making those kind of paradigmatic modes up. So the descriptive components of private ordering can be described as an institutionalized order for how it is that we do things with law on the job. So the first descriptive components and the first in order descriptive components is that employers and employees are at the helm of work relations. They are in charge of navigating the ship, which is the workplace. They are in charge of allocating the risks and benefits which relates to work. That's the first stage. If no agreement is reached on the first step, or if there's a lacuna in the agreement that made in the first step, the default is that employers govern. That's the employer prerogative, the default employer prerogative that we heard a lot about. Now, ever since the 1930s, the state is deeply involved within private ordering, within US employment and labor law, but the state role is fairly limited into three types of action. So the states constitute the general background rules for the negotiations to take place. It intervenes directly in that relationship, usually by cutting up the employer prerogative or limiting it in really extreme cases after significant mobilizing and uprising on the side of labor, the public, and of course the state enforces the first section, the employers and employees contracts. It enforces the employer prerogative, and of course, it tries to enforce its own kinds of regulations. So those are the descriptive components of how it is that we do work law. So the Surgeon General looks at this framework and says to himself, well, what can I do with this report? I can try and convince employer and employees to sign that in their contracts, but maybe it would be more easy for me to simply give it to employers on the second stage, knowing that safety and health and workplace kind of well-being is not something usually contracted in personal work relations in the US. So those descriptive components, which can be interpreted as ways of allocating power, has some justifications behind them. They're there for a reason. So the first component is there, or is justified to us in a liberal society, because those are considered mutually constituted agreements. There's no power involved here. No coercion is involved in the kind of the traditional formal view of what employment contracts are. The employer prerogative, as we just heard, has many kinds of justification. The two main ones are property interest and the special value that property rights gives employers in managing the workplace, and this kind of managerial expertise, the notion that if we hire a Harvard master in business, they can run the business much better than employees can or the state can. And state enforcement is justified, this kind of abrupt power intervention within work is justified because either the state enforces cooperation, or the state enforces the special expertise of manager, or the state has some technical capacities that employees and employers simply don't have. So the National Labor Relations Board has some labor relations policy-making expertise that the parties don't have. OSHA, Occupational Safety and Health, has some special expertise, public-oriented expertise that those parties simply don't have. So we have three components, three justifications for power, but though that in its perfect kind of version, regulated private ordering creates a balance between all of those allocations of power, between all of those justifications. So we have a system as a whole which is justified under our need to justify the application of power, and each component in itself is justified on its own. Now, the strong form paradigm of private ordering, the one that I'm attacking, would say that this is the exclusive way in which we do work law. No work law regulations happens outside of this framework. This is the canonical way in which we do work law. And this is why we teach it in classes, because that is how workplaces are run. This is how workplaces are affected by the law. And the normative strong form is this is the best way to do work law. So we can find those instincts in recent examples where we find outliers. For example, Uber drivers, we keep trying, pushing them back into this private ordering framework, because this is the only way in which we know as a society to do work law. And we also think that this is the best way that workplaces can be governed by law. That would be the strong form paradigm of private ordering. Now, where can we find subordination in this private ordering framework? And my kind of cynical answer is that everywhere we can find subordination in this framework. And I think that one of the reasons that we can now see subordination so clearly is because the curtain is kind of moving, the magic is fading of private ordering, and we can see some cracks there that we simply didn't notice before, didn't care enough to notice before. So, where can we find work subordination? In every phase and everywhere. So maybe this death of private ordering can be good news for private ordering. I'll leave it to the end. So there's numerous cracks in this strong form paradigm of private ordering. This is clearly not the only way in which we do work law, and it's clearly not the best way to do work law, capping all of our projects within private ordering. So the descriptive cracks are many. Employment contracts or contracts regarding the sale of labor no longer signed exclusively between employers and employees. Perhaps they never were the exclusive way of selling labor. So there's a shift in the basic units of analysis. Maybe employment contracts, especially in the US context, were never this kind of mutual agreement, merchant to merchant kind of classic contract law. Maybe this was always a unilateral statement of intent rather than contracts as we imagine it. The employer prerogative is being constantly outsourced, reallocated to algorithms, to markets, to other entities or to coordinate labor other than Harvard MBAs. State enforcement, at least in the US, can only be described as complete abnegation of its roles and duties in either intervening in really extreme cases or in enforcing any of those steps. And the descriptive fishery, this descriptive shifting around of basic units of analysis, basic ways in which power is actually allocated in work, creates doubts in whether or not this is also justified allocation of work. So we find multiple forms of power, contractual power, market-like power, for example, the one applied by Uber on its independent contractors that we think maybe is also kind of problematic. And we have a disbelief in employment contracts as non-coercive. I think that that's perhaps the new consensus kind of rolling around in the scholarly community. But there's also a disbelief in the ability of managers to manage their firms, to allocate resources in a smart, intelligent way. It seems that managers themselves lack that belief in their capacity. They're moving it on to outsourcing it to algorithm to manage their firms on their behalf. They move it to markets. Uber move it to a market like enterprise, to institution to manage drivers on its behalf. State expertise is also questioned. I think the common response to the Surgeon General kind of ringing the alarm bells is, so what? You're just one voice out of a plurality of other voices telling us what to do. And there's a diminished force for this belief in state expertise. And we see it on the side of courts. We see it on the side of the public. Again, I'm talking strictly in the US context. We're also seeing multiple projects actualize or utilizing private ordering as their own. The classic example in the US is immigration policy is executed through private ordering and executed perhaps fairly well, but multiple work law-oriented projects, anti-subordination worker projects are done by other means and other laws. So consumer law in the US is being activated as a gateway to engage in what was used to be a clearly work law project. So we're seeing this kind of fishing of both projects and legal instrument. So I believe that the strong form paradigm of private ordering is dead. And what can replace it? What can come next? So maybe private ordering would resurface. Private ordering was flexible enough to survive various transitions in how the labor process and the labor market worked. Maybe it will survive this crisis of faith. Maybe we will re-believe, we will rekindle the faith that employment contracts are mutually kind of constituted devices. Maybe not. Maybe we'll find other meta framework for engaging in work law, maybe some sort of a pluralism of methods and projects. Or maybe we should simply ditch the assumption that we'll have a meta framework for engaging in work law and simply do our own thing and engage in those mini projects, trying to achieve all kinds of small kind of projects and using whatever power we have or solve any problems that we find using a more pragmatic approach and simply not feel bound by private ordering and its limited arsenal of tools. So that's perhaps, yeah, I'm done. So that's perhaps my Jewish take on Halloween. So we should celebrate private ordering for all the good things that it did and note all the bad things that it did. We should preferably do it with some good food and move on with our theoretical and practical lives. Thank you so much.
Thank you. Okay, so we turn to our last speaker, Sara. The floor is yours.
Thanks very much, Eric. So I'm going to take a different and perhaps more practical and more concrete take on the subordination question than others have today. And this really arose from other projects and other thinking that I've been doing and in concert with other people, thinking about how to reconfigure or craft new structures of collective representation. And this has brought up the question and lots of arguments on whether in so doing, are we creating or exacerbating worker subordination in particular ways, or at the very least failing to address it adequately. So with that backdrop, my starting point is thinking back to some of the key labor law architects of Canadian labor law who identified three distinct sources of worker subordination beyond that of the employer. So the union, technology, and the collective bargaining system itself. And so what I'll focus on are these last two potential sources of worker subordination, the labor relations system. And here what I'll address is the question of jurisdiction and how that operates with respect to subordination and can create subordination, and technology. And that insofar as it relates to subordination through jurisdictional rules of the labor relations system for contesting these actions. So, in a nutshell, the problem with the current system is this. At the moment, the labor relations system here provides a patchwork of access to grievance arbitration, courts, and statutory tribunals to pursue worker rights, which themselves arise from a variety of different sources. And, has been clearly patterned out by other people, Brian Etherington foremost among them. This produces gaps in access in the sense of providing no recourse for certain workers for certain types of claims, or providing different access for different workers due to their bargaining unit status or whether they are in the private or public sector. So, to make that clearer, if we look at three of the key sources of rights and claims in the workplace, one is civil claims. And under our current regime, there's exclusive jurisdiction within the labor arbitrator if a particular test is met. And roughly speaking, that test is whether the issue arises inferentially from the collective agreement. If that's the case, then there's exclusive jurisdiction in the arbitrator and there's no option to seek a different forum. Furthermore, the way it's been interpreted, this jurisdiction has been interpreted in Canada, is that arbitrators in that forum don't have jurisdiction over third parties. So, for example, co-workers of certain categories, even managers of certain categories, and other parties such as insurers. There's simply no claim that can be brought in the only available forum, which is labor arbitration. The sort of second category of claims and rights are statutory, where there's a specialized statutory tribunal provided. Generally, though not in all cases. Generally in Canada, these have concurrent jurisdiction with labor arbitration. But from a practical perspective, many have pointed out that practically, effectively, it is exclusive jurisdiction in labor arbitrators. Whether it's because of practical hurdles to accessing these forums, most prominently significant delay. So if we think of human rights tribunals, for most unionized workers, the only feasible route to bringing a claim is through arbitration. The human rights tribunals are just so overwhelmed and so slow that it's not, practically speaking, a realistic recourse. And the third category is charter rights, as it happens, which are much on our mind this week in Ontario. Here also, we have, again, if the same test as for other civil claims is met, that is, does the matter arise inferentially from the collective agreement, then the exclusive jurisdiction is with the arbitrator. The other sort of quirk with the charter claims is that it's only directly applicable to public sector workers. So private sector workers have no direct access to those claims in any event. Moreover, arbitrators have only limited access to remedies where it's a claimed charter violation, only if it's within the arbitrator's jurisdiction already. So, in sum, we have, when it comes to civil claims and charter claims, in most cases, it's going to be exclusive jurisdiction with an arbitrator, meaning that a union is therefore a gatekeeper, and if the union does not facilitate these claims, that there is no recourse for those workers at all. Moreover, as I mentioned, there is no jurisdiction with these arbitrators for third parties. Typically, that tends to be coworkers, certain categories of managers, and insurance companies, if we look at the case law. But as I'll come to, that may well be changing with the intersection of technology. And in the case of charter, limited remedies, not the full panoply of remedies, and again, no recourse to a different forum for this. So, again, as others, and primarily Brian Etherington, have pointed out, there are really significant gaps in terms of access to claims. And in this respect, we can conceive of this labor relations system as providing no ability to contest subordination, so facilitating or imposing subordination of certain types arising from the structure of the labor relations system. So to add another layer to this, there's also evidence, and in some cases empirical evidence, that arbitrators might apply different analytical tests than other decision makers, including when interpreting and applying the same legislation or same law. And remedies sought and awarded under arbitration differ from those in other forums, even when there's no difference in remedial jurisdiction between the arbitral and other forum. So we can be talking about a very different type of justice, and arguably in some cases maybe a lesser justice available in the only available forum for certain workers, which would be arbitration, if they can access that forum. So, as a lot of people have pointed out, these are problems. And if we then think of how this intersects with technology, and that this might be because of technological change and more and different types of technology in the workplace, this subordination might be an increasing problem. So, the future will most likely bring more non-standard work arrangements, but also more technology of a different sort in the workplace, AI, algorithms, robots, etc. This technology is going to operate in different roles and functions than previously. And as many have pointed out, it'll take on some of the employer and managerial control roles. So as Jeremiah Adams-Prassel and my colleague Valerio, among others, have discussed, this new technology is fundamentally changing the nature of control in the workplace. Monitoring produces self-regulation due to constant surveillance, a new form of control. With algorithms, the type of employer control is different, imposing what some have labeled as rational control as opposed to technical or bureaucratic control. And as Adams Prassel points out, the effects of AI coming into the workplace have resulted in concentration of control and also diffusion of responsibility. And both of those are important to the jurisdictional question too, particularly where we have a limitation on ability to bring claims and seek recourse against third parties in the arbitral forum. So while control is changing and becoming more concentrated due to technology, it's also becoming harder to locate that responsibility. And this question of responsibility with respect to new technologies is very much a work in progress. Different areas of law are grappling with the question of responsibility and liability. What type of liability? Is it individual or collective, strict forms of liability? And where is that located exactly? Particularly when you have AI is the decision maker. Where is the responsibility to be located? What's also being very much uncertain at this moment is what primary areas of law and what lenses are we going to look at and use to answer these kinds of questions? Is it consumer protection? Is it contracts? Is it torts? Is it something else? And all of these, of course, engage questions of privacy and data protection. So I think at this point, one thing we can say with some confidence is that, in the workplace today and in future, it's very likely that issues of third-party responsibility in workplace matters will become more common than they are today, and the location of that responsibility will be somewhat different. And so this is serious given the existing jurisdictional gaps we have. If there's less responsibility for control with employer decision-making, then there's less scope for recourse and more subordination, more uncontestable subordination of these workers. With respect to this, when we also look at privacy, which is going to be a very important component of technology in the workplace, privacy is protected by myriad sources and myriad areas of law too, that differ even among the jurisdictions within this country. It's been described as a complex patchwork. So common law, statutory, including statutory torts, criminal law, charter, with very big significant differences in coverage and protection between public sector and private sector workers. The charter is implicated too, although it doesn't provide any specific rights for privacy, but there are some avenues for privacy protection within it. So privacy law in Canada is in a relatively formative state, particularly when it tries to deal with questions of technology. And Canada is lagging in that respect compared to many other countries. The new technology in the workplace is producing new challenges for how to conceptualize privacy and how and where to regulate it. This is going to also very much implicate human rights questions. Technology and privacy have huge implications for this, giving rise to new and different types of human rights concerns, intersecting with existing concerns about jurisdiction and practical access to protecting those rights and contesting subordination. So privacy and human rights, I think we can reasonably expect, are going to be increasingly important and in new and different ways to workers. And this control, the intensity of it, and the diffusion of responsibility and relocation of responsibility away from the employer, the traditional employer, and therefore access to claims against third parties for issues arising from the workplace, which are currently likely to be barred from court jurisdiction without arbitral jurisdiction over third parties, is really a significant and growing problem. So, returning to sort of a practical and concrete approach to this, as we are thinking about recalibrating regimes or new regimes, there are some ongoing older issues with the existing system that will continue to be questions, such as the role of the union as a gatekeeper, particularly for fundamental rights, access and justice, and the question of whether different analyses and different remedies ought to be applicable to different fora. The capacity of arbitrators and, for that matter, collective representative bodies with respect to certain matters. The question of private regulation of public or fundamental rights, and third-party claims in general. There are also some new considerations that will arise. Where are these privacy and technology protections going to be located? And what will that mean for access and jurisdiction? And with technological diffusion of responsibility, for even more intrusive and concentrated managerial control, will third-party claims remain outside of arbitral jurisdiction if that's going to remain the key source of contesting or workers contesting rights and violations? So again, to be fairly practical and concrete about it, some of the things that we've had to think about is the capacity and the roles for worker organizations in developing definitions, standards, and statutory and common law that are going to grapple with these things, often outside of the realm of labor and employment law. The old question of what are the appropriate forums, and should we be thinking of a multiplicity of fora or a single forum? And across what dimensions would that single forum exist? There are many calls for single forums. Many writers in privacy, for example, are calling for a single forum for determining questions of privacy. There are also many writers calling, again, for a single forum to deal with all workplace issues. Well, what about workplace issues with privacy? Where would those fall? There are many things to be sorted out in that regard. This also raises, of course, challenges for collective representative organizations. Their capacity to deal with all of these issues in this period, particularly when they're just being developed and instantiated. When we think about some of the existing mechanisms, both in collective agreements and in legislation, such as technological change provisions, are they able to grapple with the nature and the speed of change that we're dealing with here and the implications it has for basic protection of worker rights? And the duty of fair representation, is that a mechanism that's adequate for dealing with these problems? Is it something, as others have asked in the human rights context, something that should be of variable intensity depending on the fundamental nature of the rights that are in question? And some of the new regime proposals that are being discussed today, one of the traditional mechanisms that they shed is that of the duty of fair representation, sometimes substituting choice of representative, opening up the choice of representative for obligations of the representative to have an obligation of fair representation. And is that an effective substitute? I'm not sure. And discussions of various third categories of workers with, a thinner body of rights, often that does not include any form of duty of fair representation. And if we are to, consider these jurisdictional bars to any kind of recourse for workers, do we not have to consider how restrictive that is? So at the end of the day, as we look at reconfiguring workplace regulation, it's I think important to ensure and be very conscious that we don't foster additional worker subordination through the mechanisms, through the architecture of the system itself. Jurisdiction and forum and access mechanisms are going to be key. And many of these decisions, I think, are going to be made in contexts outside of the labor and employment law sphere. So it's very important that worker representatives and labor and employment law academics pay attention and participate in these developments from the worker perspective. Thank you very much.
Thank you. Because our speakers have been so disciplined, we have about 40 minutes, I think, that are available for questions or comments, both from folks here and also from people who are participating remotely. So for those who are here, if you could step up to the microphones to ask your questions, that would be great. Valerio? And
well, first of all, thank you very much. Those were 3 terrific papers and presentations. I have questions for all the panel. So the first one is to Dáire. You have spoken about the normative value that we attach to consent which is one of the, again, normative value that we attach to the idea of contract, of the contract of employment as being based on consent. And of course, all this has been discussed since the dawn of labor law. But what I wonder is, and also at the dawn of labor law, people started to say, well, yes, you can give consent to this particular contract, but normally you can only consent to this kind of contract. You can only consent to subordination unless you have the resources to be an independent contractor, build your own business. This is what the system asks for you. So I wonder whether in your conception of republicanism, this is something that can be questioned and problematized. So that's my first question to there. I have two questions for Gali. The first one is, when you say dead and no more, were you referring to the parrot sketch in Monty Python? Second, the question is about the impact that you have talked about, the impact of the model of subordination on mental health. There's an argument that actually there's very scant but existing evidence that certain forms of workplace authority can drive populism and resentment against democratic institutions. There's been some research that has mapped that the more you're perceived to be under authoritarian rule at the workplace, the more you tend to basically disfavor democratic regimes, et cetera, et cetera. So I was wondering whether these are some room in your project or not. And third, for Professor Slinn, Sara, I think what I'm wondering is, you identify elements of subordination and domination in the way industrial relations are built especially in the Wagner model. And I wonder what are the roots of that? Are they still, do we accept that those forms of domination because the alternative is anyway domination, or there is something more to that? Thank you.
Whatever order you'd like to go.
Sure, yeah. Thanks, Valerio, for the question. So, if I understood you correctly, you were asking kind of, can the Republican arsenal overcome the sort of limitations to people's opportunities, such as people having no other opportunity than to take certain roles, certain kinds of work, such as being subordinated. So I think there are a number of streams of Republican political thought, but I think Philip Pettit's would suggest, firstly, that a basic income should be available. Secondly, that but it is clear that in Philip Pettit's scheme, while there is space for non-market forms of production or relations of production, such as workers' cooperatives or the state as the employer of last resort, the predominant system of production must be a market system. And it seems to me to follow that in such a system, such a system is going to reproduce the inherent inequalities between people in the legal system of a market society. So I suppose just to answer your question quite pointedly, I think there are some things that can be done in that schema to address the structural domination of workers, but they're limited, quite limited, I would say. Yeah. I hope that answers your question. Thanks.
So thank you, Valerio. I think the parrot is dead, and no matter how many quacks the seller tries to kind of make behind our backs, the parrot is not sleeping, is dead. I think that the assertion that the workplace is a school for democracy has always been kind of empirically contested. I think that that's a great slogan. I'm not sure how it works in practice. I wouldn't be surprised if we find outcomes both ways. To tie it to my talk, I think that democratic rejuvenation is a wonderful project to engage also with our workplaces. But I think, again, trying to do that with the tools of private ordering will be tremendously difficult and confining to, and with no need. So I take it to be another project that can be perhaps implemented in kind of various ways through the workplace, but in its current kind of dead form, private ordering cannot assist in that.
I thank you for your question, Valerio. As I heard it, I wondered whether I'm the best person to answer it, since we have Eric Tucker, the labor historian, among the arrows in his quiver, is being a labor historian. So, you asked, why do we have these limitations in the system, and why do we accept these forms of subordination, or this effective subordination? Well, Etherington, among people are very critical of the way arbitration operates in this manner. He patterns out very carefully and supports the argument, or his argument, that it's sort of an institutional concern about efficiency, with sort of notional lip service given to concern about protecting the system of arbitration from incursion. And so the effect of that is that, an arbitrator will only have limited jurisdiction. They simply can't have jurisdiction over third parties unless we made some very significant, explicit changes to their statutory changes to their jurisdiction. So I'm not sure that's a very satisfactory answer. That's a fairly literal answer for why we have that. I think Eric might be able to offer a more fulsome answer to that. But fundamentally, I would say that these are, to translate what Brian, I think, is saying, is that these are political choices, largely by judicial decision makers, and certainly the Supreme Court of Canada. He's highly critical of for this.
I'll throw in one brief observation, Stefano, from my role as chair, and perhaps an understanding of collective bargaining from the first generation of industrial pluralists. And I'm thinking here particularly of Bora Laskin, who, of course, most of us will know as a former judge of Chief Justice of the Supreme Court of Canada, but he got his start as a labor lawyer and was one of Canada's first labor arbitrators. And in a very famous grievance arbitration award, he sort of compared the two regimes. So when you enter into the world of collective bargaining, you leave the world of the individual contract of employment behind. It ceases to exist, I think was the phrase he used. And so from that perspective, right, it was perceived to be a self-contained universe. And therefore, arbitration or arbitrator exclusivity, of course, he was an arbitrator too, right, would have been the starting point. Since then, of course, there are all kinds of decisions that, what is it, in the Employment Standards Act, the conservative government said, you have to, unionized workers can only go through arbitration because they wanted to take pressure off the statutory mechanism. We can go through all of them and probably look at, what lay behind the decision about how to allocate authority. Cindy?
So thanks for those papers. That was super interesting. My question is for Gali. And I think I'm having trouble understanding what you mean when you say private ordering is dead. Obviously, for the last 100 years or so, the law of work has been a melding or hybrid of private ordering and public regulation, including the regulation that sets up systems of collective bargaining. And if we look at the number of workplace issues that are resolved either by private agreement or by voluntary acceptance of unilateral employer dictates. Those are both forms of private ordering, and those do resolve, I think, still a lot of issues for many workers, especially if they're above the minimum level set by legislation. So if what you mean, and something you said a moment ago suggested that what you mean is something like private ordering doesn't have the tools we need to deal with the challenges we face going forward, that, you know, it doesn't give us the resources that we need. I would mostly agree with that. Although I would suggest that the last couple of years with the pandemic and responses to the pandemic and the remote working phenomenon really, I think, suggests that private ordering and worker preferences and labor market pressures actually still play a significant role and are really changing practices about the mix of remote and in-office work and what office work looks like. Obviously, it's done that much more effectively for people who have labor market power. That's who the labor market actually manages to work reasonably well in many instances for. But so I guess I'm pressing you for a clarification on what you mean, or whether it's a little bit more of a hyperbolic provocation, which would not be out of my, I do that sort of thing, as you know. Also.
So thank you so much. That's a great question. So I draw my understanding of private ordering from kind of a legal process origins, where in their minds, private ordering was not just agreements made by two private parties, but the state was always there. And the state was always there in setting the background rules. There's jails, there's prisons. If you steal something, you go to court and then maybe end up in prison. The state also intervenes in extreme cases. The state is there. It's always, so private ordering, ever since kind of modern understanding of labor and employment law, the state was always there. So I'm attacking a thicker version of private ordering, of regulated private ordering, basically. And when I say that regulated private ordering don't have the tools to answer what we need, I don't mean that just any private actors can simply agree on end global warming. I'm saying that this system, this ordered system of how it is that we do work law simply doesn't work. It would not fulfill, it doesn't have the tools, the capacity to answer the stakes, the data, the urgencies of the problems we need it to solve. So that's that. And another issue is that employment law, understood as private ordering, was not any agreement signed by any two parties. So the categories, employer and employees, are legal constructions that the law created to reach a specific kind of private ordering, the employment contract. Now, that's can be understood very differently from the contract of buying services between an Uber driver and Uber. So in a traditional understanding of employment law private ordering, that's not it. It doesn't have the same kind of common law obligations and understandings that we would impose on employment contract kinds of private ordering. So the old view would be the best way to, and the only way that we do work law is with employment law regulated private ordering. This is no longer the world, either descriptively and I believe also normatively. We don't think that the world would be kind of significantly better if we manage to shove all of our projects into this ancient regime. We heard it in your comments on your project. So all of those aspirations are held at the door. Now, maybe that's okay that they're held at the door. Maybe that's fine, but we need to recognize that private ordering as an institutional mechanism simply doesn't cut out to fit many more projects, not just Republican values, but kind of public health, which is kind of maybe matters to us. And it doesn't work in the same ways in which we used to think it does. Does that make sense? Some.
Okay. Sorry.
Okay. My question is to Professor George. when you talk about how we should prioritize freedom over equality generally, essentially laws in some ways, and labor law specifically, is generally employed well. There will be free riding on laws, and that's understandable. But the free riding on laws is there to make sure that other types of costs, such as transaction costs and litigation costs for workers, becomes lower. So in individualizing certain categories for workers and for employers, don't you think that creates an incentive essentially for creating of more silos, firstly, and secondly, if we are unable to tackle the 3 silo category that we have in certain countries, definitionally, of course, dependent contractors, independent contractors, and employees, then having different types of silos, how does one compartmentalize it? One, and secondly, doesn't that just raise the cost in essence to curb free riding? Doesn't that just raise additional costs? So what type of silos are we talking about here?
Okay, yeah, thanks. That was a really difficult question. I hope I can answer it or attempt to answer it. So I suppose what I've been saying is speaking from a particular perspective, where freedom is valued in that way, and I think there's a central element of valuing freedom is recognizing the importance of continuity. I thought of what Valerio said earlier when he said the origins of employment law, I suppose, there's kind of feudal elements, then the master and servant, now we have employment law, and I suppose what is next, and I suppose my go at kind of gazing into the future is that there will be more categories, and that is the best way to respect freedom as the governing value from this Republican perspective. But I suppose I don't think that's going to be realized in further categories in every single type of republic or every society. I think in some societies, what's more likely is higher levels of unionization as a way of managing the kind of the siloed existence we live in. But I think certainly the paper was written from a particular perspective and my own experience of, I suppose, the world or the society I'm in. And I think certainly I would say that continued categorization is likely to happen, or is a phenomena which is kind of not endemic, but yes, somewhat inescapable. In terms of the problems that raises, yeah, I think I haven't, and I fully accept this, that I haven't considered in sufficient detail how you would go about ensuring that the categories are respected and or policed. I think something like a right to subordination, a procedural right where, an employer is trying to obfuscate your employment status, having a right where the employer has to provide you with a questionnaire or something like that, the employer fills out the questions for you, and submits them to a labor inspectorate, ultimately, or it can be appealed to a labor inspectorate, something like that, as a way of policing the attempts to comply with the boundaries of the categories. But I know that's not realistic in every country. I mean, Ireland hasn't had a labor inspectorate only until very recently, so that's not even a thing that has existed for a long time. But I think, I suppose additional rights or further procedural rights, but I totally concede that the ability to comply with them or ensure fair compliance is dangerous. Yeah, I definitely concede that. So that's a really insightful question. Yeah, thank you.
Okay, I have a question from one of our remote participants, Tequila Brooks, whose work some of you may be familiar with. Tequila asks, she comments, really fascinating presentations. My question is for Dáire and any other speakers who would like to comment. How would you theorize about summary dismissals of the entire board of directors, most of the executive management team, and possibly up to 75% of the workforce of Twitter by the company's new billionaire owner. While board members and top executives do not have the same fundamental needs as the company's workforce, does this example indicate that there are some commonalities under human rights and workplace laws? Thank you. Little hand grenade perhaps being tossed.
Exactly. Yeah. I mean, I should start by saying I don't know enough about American corporate law, or I suppose which must form the basis for the dismissals, at least of parts of the board of management of Twitter. I suppose business reorganizations are, which is probably the only way to conceive of what's happening to Twitter from a kind of labor or commercial labor perspective. I think, very, very difficult to understand, the legitimacy for being able to dismiss so many workers, but the business is being totally reoriented, or that seems to be the proposal. And I suppose the question is, which I didn't really talk about, but I go into in the paper, is, the legitimacy of the exercise of managerial authority, which depends on the legitimacy of the business and the limits to the authority. I mean, again, in Ireland, for example, I don't think it's the case in the US that you have kind of unfair dismissal rights, whereas in Ireland and the UK, they're fairly clear and strong unfair dismissal rights. I think Pt2 republicanism can justify, and I've written about it elsewhere, judicial review of administrative actions concerning employment and labor rights, the possibility of setting up subsidiary tribunals which also address employment rights. So I think that there are responses to that which are consistent with Pt2 republicanism. But I take the point that it doesn't universally apply in practice, or not in every kind of republic that we know today. Thanks.
If there's no one else immediately, I have, I don't want to put you too much on the hot seat there, but a bit of a follow-up that stems really from the last two questions. So the notion of having, multiple categories of people with multiple rights. And in some sense, don't we already have that in, for example, I don't know if it's true in Ireland, in Canada, Ontario, our employment standards legislation has multiple exemptions and exclusions, so that actually a relatively small percentage of the workforce has full coverage under the Employment Standards Act. Unfortunately, of course, the problem is that it's not designed so that the people who have the greatest need for protection have the strongest rights. And in fact, there's a danger, and it's true in the Employment Standards Act, that it's quite often that the people who have the most need have the worst rights once they start being differentiated. So, how do you deal with that risk? You can take the Twitter example too, I suppose. The people at the top will get severance packages that will probably put them into the category of people who don't need to find work for the rest of their lives. While, of course, many of the more lower paid workers will have to remain subordinated workers. So how do you address that tension between sort of having categories in an ideal world and the problem of thinking about how they might actually be instantiated, sort of from what we know of the world in which we're living?
Yeah, so thanks for the question. I think it's very, I suppose when I was thinking about or how those kinds of my responses to what I consider to be some of these problems, the response came quickly, but the implications of the response didn't come very quickly. So to give an example, if it was the case that those who needed more labor rights were given them, my concern would be their employment would become so expensive that their jobs would be automated. So or at higher risk of automation than is already the case in many circumstances. So what seems like an intuitively attractive proposition actually has perverse consequences. I haven't even begun to thought about the practical application of, other than having a right to subordination, namely a right to have your employment rights kind of determined accurately, if at all. I haven't thought about how you would go about doing that. And I mean, it seems, like you would need a much larger state machinery than exists in many countries to do that. And I suppose there is my understanding of kind of some of the principles of the transition to socialism and to communism are, these mantras of from each according to his ability and each according to his needs. That can there be a harmony between those, or are they necessarily opposing? Can they actually be related to each other? And that's what I've tried to suggest, that they can converge. But in terms of actually making that happen, I can't say for certain. Really, I'd have to think about it a lot more. But I think if it was the case that there was something like a right to subordination, a procedural right to have your rights categorized, and there was sufficient state machinery to supervise that process, then potentially that could happen. Because, I mean, as you say, the reality is that senior executives and the likes of Twitter and whatnot are able to freely bargain anyway for, they're going to be getting large severance packages, but secondly, it's likely that many of these people are able to freely bargain for very, very substantial amounts of money and high quality rights, in the same way that many tech workers have, amazing bargaining powers. Simply put, they just have powers that those at the bottom don't. But other than having a more advanced kind of state supervisory machinery, which I'm not aware, I don't know enough about the American or the Canadian position, but my guess is that it wouldn't have that kind of power, and it certainly isn't the case in Ireland either. But that would be my starting point. Thank you.
Thank you. Any of the other panelists have any last comments or any questions? Let me just double check to see if there are any more. No, there are no more questions from our remote participants. So, well, if that's it, then let me take this opportunity to certainly thank the three panelists this afternoon for their outstanding presentations. And I'm not going to thank myself, but I'll thank the other two panelists this morning for their outstanding presentations, and thank my colleagues Valerio and Sara for organizing this event. And last of all, of course, to thank everyone here and everyone who's participating remotely for joining us and for engaging with us. So, and so, that I think brings us to an end. So thank you all.